Welcome. My name is Paul Holden, and I'm the President and CEO here at the Burnaby Board of Trade. And before we start, I'd just like to take a moment to recognise that we here at the Board of Trade are on the traditional homeland of the Hunkaminam and Skohomish-speaking people, and we extend our appreciation for the opportunity to hold a meeting on this territory. In today's event, I'm joined here by Jim Wu of Forte Law Corporation, who's going to walk you through what employers need to do and not to do to avoid legal claims or complications. And by the end of this, you should have a really good understanding of what you need to do as a business owner with respect to the laws surrounding hiring and firing of employees. I'm going to start by thanking our partners. This webinar today is part of a series of webinars, programs and events that we hold under our Centre for Burnaby Business Resilience, which is something that we set up during COVID. And it's now a really core part of the work that we do to ensure that businesses have the tools and resources to develop the resilience that we saw was needed so much during COVID. Our platinum partners for today are the BCIT School of Business and Media, Simon Fraser University, Douglas College, and Electronic Arts. And our gold sponsors are Hemlock Printers, Ricoh Canada, TD Bank Group, Parkland Corporation, and Mitchell Press. And I'd also like to thank, and you can see them now, our annual partners, who are a fantastic group of organisations who work with us throughout the year to support the work that we do on behalf of the business community. So I'd like to take a moment to thank the many great organisations that you can see on the screen right now. We do have today an American Sign Language interpreter joining us, and hopefully you're able to see that person on the screen. And thank you very much for joining us today. I'd like to introduce our speaker now. We're going to get underway. So this is Jim Wu of Forte Law Corporation. Jim prides himself to be a problem solver and a relationship mender who's keen on putting out fires arising from various stages of an employment relationship, from hiring to firing and everything in between. In addition to having conducted 6 trials in the last 2 years on wrongful dismissal cases, Jim's also very familiar with the administration of employment insurance benefits, as he's adjudicated over 10,000 EI claims during his 4 years working as an EI adjudicator. So I'm going to hand it over to Jim. I'm going to slide just off screen slightly so that Jim's got the screen to himself, and then we'll be back later on for questions. We do have a Q&A area, obviously on the screen here, that you can put your own questions in as we go through the presentation, and we'll get to those at the end of the session. So Jim, I'll slide round. I'll give you the end of the table, and I'll hand it over to you.
All right. Thank you, Paul. Thank you, the Burnaby Board of Trade, for having this opportunity to present to everyone about employment law. So I'll get right into it. Our agenda today, we're going to cover 3 items. We're going to cover what is employment law. I'm going to touch upon what are some new developments since COVID-19. And of course, I'll make sure there's time for questions. So jumping right in. Employment law encompasses 4 dimensions. There's minimum standards, there's human rights, there's health and safety, and finally, there's contractual enforcement. So what are each of these? What is it in a nutshell? Well, minimum standards is the government sets standards, and you, as the employer, as a business, you got to meet them. What is our general advice when it comes to minimum standards? Give your employees more than just minimum standards, and that can include a cent above what's required. That will guarantee compliance. Some smart moves that can get you into a lot of trouble. So I always use this example, and businesses are probably very familiar with this. The example of hiring contractors as opposed to employees. Let's talk about the risks of doing that. So we have this example here. Diana works for ABC as a consultant. ABC Networks engages Diana's services as a contractor. So the arrangement is ABC pays Diana $600 a week for her services and has Diana take care of her own taxes, her own EI, her own CPP, and they ask Diana to invoice the company every month. Diana charges ABC GST for her services, and she works out of her own office. Now, the issue here is Diana's kept detailed logs showing that she's consistently worked 14 hours a day, 5 days a week for ABC. She's very committed to ABC's success. The biggest problem here is that, and this is from the government, you may think that Diana is a legitimate contractor. However, there are common misconceptions, and just because you have someone engaged in services who takes care of their CPP, takes care of their EI, takes care of their taxes and invoices you once every month with GSTs applied to it, that doesn't necessarily mean that person is a contractor. It can still very well mean they are an employee. And the test, to summarize it, is for the government is, if it smells like an employee, if it walks like an employee, chances are that person is an employee and not a contractor. I always say to businesses, look, at the end of the day, the person that's being really, the entity that's being at a disadvantage is the government, and the government is, it's an honor system that the government's built. And if everyone's able to hire contractors, not pay CPP, not pay EI, everyone will be sleeping in on this scheme. So what's the issue with Diana? Well, ABC has broken the law because the issue right now is under the current arrangement, Diana is paid $600 a week for weekly total of 60 hours of work, or $10 per hour. So how I figured that out was, you recall, she works 14 hours a day. 14 hours a day, 5 days a week. So that's a total of 60 hours of work every week. And if you divide that by how much she was making, she's making $10 an hour. Our current minimum wage, as you can see, is $15.65 an hour. So really, the proper calculations for Diana are as follows. This is where it gets really complicated and where a lot of employers get deemed by the law is, it's not as straightforward because Diana is also making overtime. So the first, how you break it down is, for her first 8 hours, she's making $15.65, and that basically gets you $125.20. The next 4 hours are at regular overtime, which is time and a half, and that gets you 93.9. And then because she's worked 14 hours every day, she is also entitled to double overtime. So really, her, Diana's daily total is 281.7. But that's, the fun doesn't stop there, folks. If you think that, so this is a skill testing question, which is, what is Diana's weekly pay under the law? Is it A, the very straightforward math where you multiply that number by 5, or is it B? And if there's any accountants watching, I challenge them to correct me otherwise. But my take is, it's option B, not option A. And here's why. Overtime kicks in many ways. It kicks in after 8 hours a day, or if the employee has exceeded 40 hours a week. So if we look at by day 4, that's when the transition takes place, because by day 3, Diana's already accumulated many overtime hours. So she really needs to work just 4 hours of her normal pay in order to finally get into the overtime bracket. And what that creates is a surplus of overtime for her and an increase. So you can tell that the fallout for ABC here is that depending on how long this is going on, they could be in a lot of, they could owe Diana a lot of money. So if you look at the annual example, this is how much ABC has paid according to their current arrangement of $600 a week, which is $31,200. That's money they've already paid to Diana. But they actually kept Diana employed for a year. They actually owe Diana an additional $46,924.80, and that's all derived on her minimum wage. And that's just minimum wage. It's not anything spectacularly high. And on top of that, they have to pay her 4 to 6% of vacation on all the wages they owe to Diana. And if this it's typically pretty common that once you get audited by one entity, the other entity follows. So a lot of businesses, what they tend to do is, this tends to happen. Next thing you know, the federal government comes knocking on their doors, and so does WCB, because at this whole time, this contractor arrangement basically prevented the business from contributing into provincial taxes, federal taxes, EI, CPP, WCB premiums, all of which employers are required to pay and contribute. And because they've been trying to essentially not pay those, the government is now knocking on their door. So this is it can be potentially devastating. But I like to say that this is where the liability ends. Unfortunately, it's not, because under the Employment Standards Act, you can also be assessed with penalties. And depending on which infraction this is for ABC's company, they are looking at a number of infractions. How many per se? Well, let's see here. Based on my assessment, it looks like ABC has pretty much broken 9 sections of the Employment Standards Act. And by that token, you're looking at a fines of potentially from $4,500 all the way to $90,000 just for, so that's the question you need to ask yourself. Is it worth me incurring a potential fine of $4,500 to $90,000 just so I could arrange this contractor relationship with my employee? Or is it better for me to just have a standard employee relationship? What are some good practices to make sure that you are in line with minimum standards? Number one, make sure all employees submit timesheets, especially if they're working at home. That is one of the biggest developments since COVID-19. Before, working at home was a privilege. It still is a privilege. However, more or less, a lot of employees are exercising it fairly often, and it is becoming more of a norm in the sense that if you do not extend the privilege to the employee, that employee may look elsewhere, and if another entity gives them that privilege, they may decide to go with that business instead. Make sure you practice what you preach, in the sense that if you want employees to work standard hours, make sure you assign work to them according to standard hours as well. On the note of text messages and social media, more just text messaging, make sure you do it all within work hours, because every text message you send to an employee, the time that the employee takes a look at that message, that's all considered to be work, and it's all compensable payments that you have to make. So next time you send a message to your employee, just think whether that will get you potentially an hour or two over time that you could otherwise avoid if you just send that text message during the standard work hours. The last part is set policies on working at home, because essentially what you want to, if you want to foster a sense of accountability from your employees, you need to set the policies yourself to make sure how your business is run. So if your employees insist on working at home, make sure they commit to the schedules and have them give you schedules and make sure you follow up with them. And that when they are, especially when they're on their breaks, that they actually do go on their breaks, because if they work during their breaks, well, there's no longer a break. The whole purpose of a break is you don't perform work.
Jim, we have a question.
Yes.
Back a few slides, the question says, is what if Diane is a registered professional engineer working on salary for a tech firm? Can ABC avoid paying overtime?
That's an interesting question, because it's more importantly, it's the former part. So if Diana is hired as a licensed engineers are exempt from the Employment Standards Act. So there are certain professions. For example, myself, I'm a lawyer. I'm expressly exempt from the Employment Standards Act, and that includes basically exemption from being worked. There's a section in the Employment Standards Act that prevents employees from being worked excessive hours. So literally my employer could, they don't of course, but my employer could work me to death, and that's illegal. So lawyers are some of those professions, doctors, engineers. They're all basically listed in the Employment Standards regulations, but that will probably be the short answer for Diana if she's an engineer. But what's more importantly is if she's hired as an engineer, she better be carrying on the duties of an engineer, because if she's really hired as an engineer but performing the duties of a receptionist, then we have a problem.
We have two more questions. How long do you recommend timesheets are kept on record for before you can dispose of them? And does a timesheet need to be physically signed by an employee to be valid, or is it acceptable just for an employee to submit it digitally?
So the first answer will be 6 years.
6 years.
Yeah, and the answer to the latter one is ideally if you can get a signature, that would be best. However, digital signatures are also valid in the sense that if you have the employee email it to you, that's also considered valid as well.
Okay. And a third question, what about an email if you send an email after hours?
Right, so that all depends on how readily available the employee is able to access it. If the employee has, let's say, Outlook or some other email device installed on their phone, and every time you send an email, they get notified of that, then that constitutes as work hours. Of course, if the employee is only able to access the email through the company's computer, which is only accessible when they get to work, then the answer will be no, because they're not expected to access that system past work hours.
Thank you.
The last part is what to do if employment standards does come knocking, and this does come fairly often. Number one, do not ignore them, because that only creates more problems. Make sure you consult an employment lawyer and ask for more time, and be prepared to then at the end to pay the employee some money. And I say this because you're looking at the enforcement of employment standards here. Employment standards are minimum standards, and when you've been alleged to have shortchanged your employee on the minimum standards, the government typically has already taken fairly unfavorable impression of you. So the quickest way to basically resolve all of this is to be compliant, recognize your fault, and be prepared to arrange some sort of funds to resolve the situation. And most importantly, treat it as an experience, as a learning one. Compliance does take time and it does take money. Our employment laws are fairly straightforward, but there are some nuances that businesses sometimes do take a while to understand. And of course, don't take it personally. This is the cost of doing business. It goes every business. It's very common for many businesses to get audited. So don't take this as sort of a personal tragedy on your end, because it's not. Moving on to human rights. What is it in a nutshell? In a nutshell, do not discriminate against your employees. What is our general advice? The question we usually ask is, do you discard your weakest employees, or do you help find them ways to overcome their weaknesses? Businesses that typically discard their weakest employees you are alleged more often than not to be discriminatory, whereas businesses that invest and find ways for their weakest employees to find them accommodations tend to have less complaints. Yeah.
We have a question. With regards to sales reps, how does the law view reps that are paid only on 100% commission on their sales? And are there any changes in employment law pertaining to the sales rep role within BC?
Right. So with respect to sales reps, there's under the regulations, there are very limited categories as to what are considered to be positions that can fall into those categories. I believe it's limited to car sales, heavy industrial equipment, and agricultural equipment. The law concerning that is the employee must be paid at minimum wage. So in other words, if at the very end, the commission sales do not reach the equivalent of, let's say the employee is required to work 40 hours a week, and the commission sales basically generate an amount that's under 40 times 1565, then the employer has to match that amount at the very least.
And so does that accumulate over a certain period of time? You wouldn't want to measure it weekly? Right.
So under the Employment Standards Act, you have to pay at least semi-monthly, so per pay period. is how they measure. So for every pay period, if the employee's sales revenues fall below minimum wage, then the employer's obligation is to basically at the very least like match the minimum wage for the employee.
So if they had one that was below and then two that were above, you'd still pay them for the one that was below?
That's right. So how it works is, let's say in a semi-monthly pay period one, the employee's total revenue, total sales basically fall into a number that's $5 below minimum wage. Then the employer basically has to subsidize another $5 to make that compliant.
We have one more question.
Yeah.
We have agents working different shifts. How does sending an email to all staff while staff are not on shift impact this?
Right. So there are many ways which you can, one thing in the employers, one creative solution to this is I've seen employers basically have a designated link where they advise all their employees, okay, this is your designated link. Just go there in your spare time to check out your shifts. That's one way to get around the email situation. And also notifying an employee of their shift times. That's actually one of the express exceptions to work. So under that category, you don't need to worry too much, but it's usually, you'd be surprised at how many discussions that were related to work follow up after the employer sends a text message saying, are you available for work that day?
How has the dismissal of sales reps changed, if anything?
So we'll be getting on to dismissals very shortly, but the short answer is not much at all.
Thank you.
And here are some smart moves that can get business into a lot of trouble. So I'm just going to go to the next slide. So the test for discrimination is the complainant has to possess a protected characteristic. And what are the protected characteristics? I apologize if this was very small, but there are many that our human rights cover. I believe that the total number is probably 17 enumerated grounds. And the second step is that the complainant expresses an adverse impact with respect to his or her employment. In other words, the ground is basically the complainant. The employee has either been terminated, experiences a cut in wages, something negative to his or her employment. And the third factor is that the protected ground is somehow linked with the negative experience. So let's go through some examples. Okay, so I think everyone's familiar with the classic example of an employee, a female employee notifies her employer that she's pregnant. And then the next thing you know, the employer has her termination letter telling her we require someone more reliable. So that's a very classic example of a prima facie case of discrimination. You have the protected ground, which is sex, and then the employee has faced a termination, which is the adverse impact. And then the third one is very clear that the employer has terminated her because of her sex, because of her pregnancy. But some cases are much more nuanced. For example, this case here, Patricia had to fire her secretary, Pete, whom she noticed had been recently taking prolonged bathroom breaks and have increased in frequency. Patricia had been trying to ask Pete a number of times if he's doing fine. And every time she tried to ask, Pete would cut her off, insisting that I'm okay. Patricia eventually had to fire Pete after he disappeared for 2 days. She would later learn that Pete had been diagnosed with Crohn's disease. So typically these are the claims that are submitted to the Human Rights Tribunal. There isn't really a very definitive answer as to whether this can or cannot be discrimination. In the one sense, Patricia wasn't aware, but the law does require Patricia to make inquiries about what was going on. And she was going on, but to the extent where the 2 days where Pete was missing, you could say that Pete had a responsibility to notify Patricia, but we don't really know what those 2 days absences were. If it were basically Pete receiving medical treatments at a hospital, then Patricia may be in a very tough situation where she did not exercise her duty to accommodate Pete by basically giving him the absence for him to take the medical situation, and more importantly, preserve his employment in the sense that she will be willing to find ways. It goes back to what I said earlier about weakest employee. Here you can say that Patricia, recognizing Pete had weaknesses, decided to fire him instead of trying to find ways to accommodate him. Yeah.
What is the standard in regards to responding to job applications that require accommodations when there is a public diversity statement? Is there legal obligations to respond, or is it solely on the discretion of the business or hiring manager?
Right. So that pertains more to employees who have not been hired but are still in the process of applying. So the answer to that is there's a legal answer and there's also a public relations answer. So I'm obviously not a PR person, but the legal perspective is make sure that whatever you say is not discriminatory. And generally what we say is if you can avoid giving an answer, avoid giving an answer, because that's usually the safe way to play it. Now, if you want, just if your company does have a policy where there is, let's say if you have a certain affirmative action policy where you provide certain postings for groups that were historically disadvantaged, that is actually an exception under the Human Rights Code that is permitted, and that is actually not considered to be discriminatory. So there are ways, there are features within our legislation which you can utilize to promote inclusivity, and I'm a big proponent of inclusivity. So for those, and those questions have been asked more and more by candidates who are BIPOC. So I think the obvious answer for employers is if you want to play it safe, the dilemma is if you try to avoid that answer, you may not be seen to do. So perhaps having us, this actually may be a good time for you to consider sort of what is our approach to diversity. What is our makeup of our business, and how do we embrace diversity? Because you will have these potential candidates who will come to knock into your business, and at that time you probably want to be happy to discuss how well your business promotes and achieves diversity. All right, so moving on to health and safety. What is it in a nutshell? It means providing your employees with a safe workplace. And the general advice we give is when your workers do not feel safe, they will not continue working. It's that simple. One thing I've been noticing with a lot of businesses is a lot of businesses do not have a respectful workplace policy. And this is quite alarming because a respectful workplace policy is required under law, and not having one can result in fines. I've included a link where you can access all these information to make yourself compliant, but the standard for respectful workplace policies are as such that you need to have a policy in place where employees are aware of what happens in the event they've been bullied or harassed. What is the investigatory mechanism? We had to have an investigation mechanism and one which the employee will be aware of the outcome. Not having any of those can get you in trouble with workplace with WCB. The one tidbit I want to mention about respectful workplace policies is, unfortunately, the WCB is also very lax in terms of the actual standard to which employees need to be aware of anti-bullying and harassment. This is they circulated one PowerPoint presentation. Some of the recommendations are very unadvisable. Remember, one of them is the topic is this is how you teach your employees to deal with alleged bullies, and one of them, the recommendation is have your employee confront the alleged bully and give them a copy of the respectful workplace policy and point to the section which that alleged bully has been violating. That does not jive with reality. My recommendation is if you bullying and harassment has means to cause a lot of attrition in the workplace. So do take it personally, do take it seriously. Take some time to actually formulate a policy with your employees so that way they feel safe and you feel respected, because that's one of the pillars that can ensure longevity in their employment with your organization. All right, and the last part is contractual enforcement. And this is in a nutshell, how do you maintain, start, and end an employment relationship? For us, so we're going to be talking about mostly, and our general advice is if you don't have it in writing, don't expect a judge to enforce it. Employment contracts are very unique in the sense that that's exactly what's stated. You have a contract that contracts are always drafted by employers. There's a unequal power imbalance. Therefore, the judge's expectations is that employers, whatever protections you seek on that contract, you better have it crystal clear, because if it's not crystal clear, I'm not going to enforce it. In fact, I'm going to give the employee all the benefits that the law can provide. So one example of this is, and some smart moves I can get businesses into law, getting a contract off the internet. Please don't do that. That's almost like a recipe for guaranteed disaster. And the second thing that I've been noticing quite alarmingly is terminating an employee for cause when none exists. I'll be discussing about what it means to terminate an employee for cause. But so how terminations work in BC and Canada is if your employment contract does not mention anything about how much severance you need to give an employee when you fire them, does that mean you can fire them without giving them anything? I get this question a lot. So in Canada, that is not at all the case. It works that way in the United States, but in Canada, how that works is if you fire an employee, you must give an employee reasonable notice. So that's the state of the law. So to answer anyone's question, can I fire an employee without giving them any reasonable notice? The answer is absolutely not. Yeah.
One question. I work for a nonprofit board and I am the only employee. How does respectful workplace policy work?
Right. So in that, I would imagine that you have something with someone to probably report to and some other, probably the board that you interact with. So in that case, the respectful workplace policy still applies to you. And as well as any future hirees down the road, they will also be integrated. So that will kind of be the short answer to that. Going on back to termination. So the real question is what is considered to be reasonable notice? See, there's another question. Or, okay. So reasonable notice, it can come in many forms. It can come as actual written notice. So that's where, say if I'm getting fired, that's when my employer gives me a notice saying, Jim Wu, as of 3 months from today, your employment is going to be ending. So my employer has in fact given me 3 months of actual written notice. There's salary continuance. So how that works is you keep the employee on payroll, but you don't actually assign that worker any work. And then the last part is paying you a reasonable notice. That's otherwise known as severance pay, or a combination of any of the three above. What is reasonable? Well, we have one guidance from the courts, which is it cannot be lower than minimum standards. And what is minimum standards? That can range from absolutely nothing to a maximum of 8 weeks here in British Columbia. And it's all based entirely on how long the employee has been working. And when I say working, be mindful that working also includes any time the employee's on leave. So the employee's on maternity leave, parental leave, that adds to the employment duration. So keep that in mind when you calculate that, the amount. Yeah.
We have two questions. Is respectful workplace policy only for interactions between employees or also between employees and clients or members of the public? What is best practice if a member of the public harasses an employee?
Right. So the answer is yes, it extends to how the public can also have the potential to harass employees. And yeah, it goes back to what I mentioned earlier. There's got to be a reporting mechanism. There's got to be an investigation mechanism. In terms of the actual details itself, that's for every business to figure out, because every business is different from their own in terms of the clientele you deal with and the interactions that are in place. Returning to reasonable notice. So
I was just thinking about managing questions. Jim, how much longer do you think your presentation? I'm conscious that we don't want the questions.
Oh, sure. Probably 5 minutes.
Okay, so we've got 15 minutes. So we'll maybe, Sarah, we'll just clump the questions together as they come in, and then we'll let Jim race through, and then we'll have a
Yeah. So you have minimum standards as reasonable notice. But in addition to that, employees are also potentially entitled to more reasonable notice, and that's based on their age, their nature of the job, their length of service, and the availability of other jobs. This is subject to the duty to mitigate. So what that means is employees, when they've been terminated, they have the expectation to look for work immediately. So if you have a case where one of your employee is terminated and finds a job the very next day, then essentially your whole notice period will be shrunken to nothing, because that employee has severance is meant as a compensation. So when you're not at a loss, you're not going to get any compensation. Firing for cause. Before I go there, you can also set the reasonable notice through your employment contracts. This is another reason why we highly recommend all businesses have a written employment contract, because through the employment contract, the law is very simple. It has to be higher. It has to be at least minimum notice. Therefore, whatever amount you specify, as long as it's higher than minimum notice, as long as it's either minimum notice or higher, that will be legal, and then that will save you a lot of potential liability. And to give an example here, at the very last role, where you have an employee working for 8 years, the difference between not having a contract versus having a contract is, let's say if you have a contract that says we'll pay you minimum standards, then you're left with 8 weeks of notice. If you don't have a contract, then that employee is probably looking at as much as potentially 1 year of notice. So 2 months versus 12 months. Firing for cause. Before I go any further, our courts recognize this to be the capital punishment of employment law. So this is like a very high threshold, and there are 3 steps involved. The first one is, what is the nature and extent of the misconduct? In other words, what did this employee do? What are the surrounding circumstances? Namely, why did the employee do it? Or how did the employer find out? How has the employee reacted in the allegations? And to tie it all together, is a dismissal proportional response to the alleged misconduct? Does the punishment fit the crime? Because when you terminate someone for cause, you're essentially telling that employee, I don't care how hard you worked. I don't care how well you worked. What you did was so bad that I'm willing to basically fire you without a cent of severance. That's really harsh. My having around 2 Supreme Court cases that span 2 weeks on just cause, having lost one of them, having also won one of them, my overall take is these are really expensive trials to run. And while it's tempting for employers to engage in just cause termination, I often not always advise against it just because of the cost involved, and it's generally not worth it. There are a lot of repercussions involved. I was going to talk about, there were some cases recently reflected in the news about time theft, but I'm sure like probably one of those will come up in the shape of a question. So I think this is probably a good time for me to stop here and open the floor to any questions.
I've just got one quick one myself. You mentioned 2 things: the duty to accommodate and also the employee's duty to inform.
Right.
Can you maybe expand on that a little bit? Where would somebody go to find out what reasonable accommodations are?
Certainly. So if we use the example with Patricia and Pete, I think if Pete has been managing his Crohn's disease symptoms very well, and then just mysteriously disappeared off the face of the earth, and then Patricia fired him afterwards without having any idea that he had any symptoms whatsoever of Crohn's disease, and then Pete was to say, well, Patricia, you discriminated me by firing me because of my Crohn's disease. I think Patricia would have a very good argument to say, I had no idea. That just never ever occurred to me. But to the extent where Pete has to tell Patricia, I have a medical situation, I got Crohn's disease, that's not really required, because the example I gave, like there are certain cases where it becomes almost the duty of the employer to inquire.
So, and are there guidelines about what you can ask and what you can't ask?
There are. So ultimately what it is the employer can ask as many questions as they want. The employee has the right to refuse. Yeah.
We're just waiting on any more questions.
Well, if we're waiting for some questions, let's jump into the one that was in the news recently.
Oh, sure.
Because there's a lot of talk about,
right.
If an employee, for example, if an employee is contracted to work 40 hours a week and they're doing it from home,
right,
and they put their job description,
yeah,
and they say, well, after 30 hours, I've done what was in my job description for the week, so I'm done. Or in the cases where people have to keep timesheets, and somebody's kept a timesheet and somehow the employer has found out that it was wrong.
Yeah, so I have many things to talk about for that case. First thing is, unfortunately for businesses, this case is not set a precedent because it was actually not before a court, it was before the Civil Resolution Tribunal, not part of the judiciary. And to make matters worse, I personally think the decision was made incorrectly in all fronts. The evidence was not taken into in a manner that it should be. What happened in that case was the employer installed some time management tracking system to at the behest of the employee, because the employee complained that she was having difficulties managing her time. I guess if I recall correctly, part of the task was for her to utilize that software so she would have an understanding of how she was managing her day. And she actually reported to the tribunal person that I have difficulties using this software, and that alone should be like a triggering mechanism. Okay, you have difficulty using the software, so there's a very good chance that the data that your employer amassed to terminate your cause is in fact flawed because you may have entered it incorrectly. But this case is also important because it talks about the reality of why timesheets are important for both employers and employees. When you submit to timesheets, you make sure you take a look at them, because for employees, these timesheets, they are you submitting a legal document to your employer in exchange for compensation. Your employer relies on these sheets to basically pay you for the time that you alleged work. If at the end, those time sheets do not actually accord with reality in the sense that you are actually watching Netflix for 40 hours and not actually doing accounting work for 40 hours, then yeah, the employee would have there is a likelihood that the employee could be terminated for cause, and the employee could also be in a situation where they have to pay back the employer monies that were otherwise not paid, should not have been paid to that employee.
We have a question. Can you please touch on termination for non-performance? What are the steps to doing that correctly?
Termination for non-performance, we don't, that's, so I've been an employment lawyer for almost 6 years. I never actually heard of that term. I suspect you're probably referring to a termination by way of frustration, contract being frustrated. So this,
Or the results, I guess, not being what was expected.
oh, I see. Okay. Right. So in that case, it will be very likely a termination without cause, because terminating someone because they're not performing the contract well to standard is not a standard for just cause termination. Unless that employee was so negligent and so incompetent to the extent that the level of incompetence or approaches at a level of being malicious. Otherwise, that is what you're looking at. How to best approach it? Have a written contract that states either a probationary clause, or what I always suggest is have a contract that says we'll pay you will terminate you in accordance with employment standards, because under the Employment Standards Act, it's actually built in. Those first initial 3 months are built in as a probationary period, and the Act recognizes that, because if you've been let go during that period under the Act, your entitlement is nothing.
And I guess the question might also mean if someone's been in the job for a while and their results or performance starts to decline, is there a process in terms of meetings, documentation, etc.?
There is. Generally speaking, we usually have businesses commit to putting employees on what's called a performance improvement plan if they suspect that terminating the employee otherwise could result in a potential human rights complaint. So, for example, Pete and Patricia's example, let's say Patricia makes accommodations and eventually just realizes this is not going to work. In order for her to minimize her extent of exposure and to have like a document where she says, I terminated you because of performance issues, not because of your Crohn's disease, that would be the way to go. But my overall advice is if human rights is not an issue and it's simply a matter of just economics, then proceed and terminate the employee without cause.
Would you clarify what firing for cause is? Is that different from just a regular firing of an employee where you give reasonable notice?
That exactly. You pretty much just answered the question exactly. Firing someone for cause means you give the employee no notice, no severance, nothing.
Next question. What legal risk is there with requesting employees to return to the traditional workplace, especially those who have been granted approval to work from home office since the start of the pandemic? Is there a certain timeline of creating a new norm expectation to permanently work remotely? This is the case where the work can be performed remotely.
Right. So that question, there's always, when you, it goes to what I said earlier, working at home is a privilege. It's not a right for an employee. So the first thing for businesses to explore is if I were to take away that privilege, what would be the ramifications on the employee? Now, let's say if the employee has requested the need to work at home because of her human rights issue, because of the disability or some other aligning factor, then that privilege actually becomes a right because you need to accommodate her. But putting that aside, if there's no human rights accommodation, businesses can insist immediately that all of their employees report to work, not remotely, but actually physically at the location, keeping in mind that they are doing it in a manner that complies with health and safety protocols. But the most important part to also remember is that's the law. Reality is different. If you were to make that policy right now, what are the chances that you might experience a mass exodus of your employees out of just outrage and you decide to go somewhere that's able to continue to give them that privilege?
Can you explain constructive dismissal?
Certainly. So constructive dismissal is where the employer terminates an employee, but they'll actually, to the extent of giving the employee a notice saying, I'm terminating you as of this date. It occurs when an employee or changes a material term of employment, such as I'm going to cut your hours by 60%, I'm going to cut your pay by 60%, or I'm going to, you are the GM of my store, I'm going to basically have you scrub toilets for the rest of your time working here. It's where the employer changes an aspect of the employment so fundamentally with the express intent of terminating the employee.
Another question. In the past, employers have claimed that an employee who is a manager or salaried employee and no timesheet is required. Therefore, their overtime is included in their pay. This employee is not a professional like an engineer.
So unless your position is expressly exempt from the Employment Standards Act, from overtime, so, and there are positions like that. Commissioned salesperson are one, managers are another example. Otherwise, even if you're under salary, you must still pay the employee overtime pay. Salary is not a way out of the overtime machine.
Next question. My employee has worked with us for 2 years. We will be giving them 3 weeks notice. Do we still have to give severance?
It will depend on a lot of factors, including whether you have an employment contract or not. If you don't have an employment contract, that employee is entitled to more severance beyond 3 weeks. And
But thanks a lot, Jimmy. Appreciate you joining us again today. Today.